Welcome to National Security Law Today, the podcast of the Standing Committee on Law and National Security. I'm Elisa, always here in my individual capacity. There was a lot of news this week in the area of AI and in national security, and we decided it was time to bring you a few of those updates. So first, the White House has issued a new executive order that arguably modifies the earlier EO on AI development. We will add a hyperlink to that new EO in the notes to our cast. But the order directs agencies to develop a voluntary framework for securing frontier AI models within 60 days. Wow, that's fast. Under the framework, AI developers will provide the federal government with access to leading-edge frontier models 30 days before they release the models to any other organizations. The framework will also allow AI developers to work with the government to, this is a quote, select trusted partners that will have early access to covered frontier models to promote secure innovation and strengthen the cybersecurity of critical infrastructure. This all sounds positive, right? Trump's order specifically bars EO language from being used to create mandatory requirements for AI developers to pre-clear their models with the government. I imagine that was a nod to the private sector, but there may be also good reasons to do that. Leaders at the National Security Agency, the Cybersecurity and Infrastructure Security Agency, the CISA, and the National Institutes of Standards and Technology, we'll call it NIST, among other agencies, are part of the group that is supposed to develop this voluntary framework. And these agencies are also tasked with creating a classified, quote, benchmarking process to determine when an AI model meets the threshold for voluntary review. So among other things, this EO tells the Treasury Department to work with the NSA and the CISA and other agencies to form an AI cybersecurity clearinghouse. The group was supposed to then work with the industry, work with operators of critical infrastructure. You know, many of those are actually private sector companies to coordinate on new software vulnerabilities. And what I think might be interesting is, are they talking about the electrical grid? Are they talking about protecting nuclear power plants? If so, this seems like the right direction. So we're going to keep an eye on that. But most importantly, we're going to talk to someone who knows a lot more about it than me in just a few minutes. Now, moving on, law firm Kirkland & Ellis, which is the world's highest grossing law firm. It's apparently spending $500 million to develop its own proprietary AI technology into which it plans to put the, quote, collective intelligence of its lawyers. Well, the lawyers that I know who've worked there have quite a lot of intelligence, so this will be interesting. And I wonder if they'll end up selling that, or I wonder if this will be a new profit model for law firms that are otherwise somewhat undercapitalized, as we've observed over the last 20 years of mergers. All right, now AI depends on data centers, and SpaceX claims it will deliver just that in space. That is what they say they're going to do, and that appeared apparently in their S filing for an initial public offering. SpaceX says it'll begin deploying these data centers in space as early as 2028. Remember that date, and in early 2028, I'm going to bring this up again. What Elon Musk said, though, was important. He said that they can run on solar power because they'll be closer to the sun. However, TechCrunch reports that without water, SpaceX cannot accomplish this, and that water access presents a serious risk factor to these space data centers. And I don't know what they said about whether or not that risk was fairly identified in the S filing or not, but we're going to explore this in a later cast and maybe multiples. Now, not all news has to do with AI. The FT reports that the United States is in talks with NATO to expand nuclear-capable deployments in 6 unnamed countries in Europe. The FT reports that these deployments would involve dual-capable aircraft, which are able to deliver nuclear strikes. And it also says that Poland and Baltic states on the European eastern flank are involved in some of these talks. Right now, Putin is not enjoying hearing this. I'm not going to suggest that he lost bodily function, but that is something he should think about as he continues to encroach in Ukraine. But moving to the details of the new EO, we knew it was time to circle back to a friend of the cast, Josh Geltzer, former legal advisor to the National Security Council and Deputy White House Counsel. And now he's a partner at another very, very smart person law firm, WilmerHale. All right, Mr. Geltzer, we have talked previously about the position of the White House in the original executive order pertaining to AI. Do you want to talk about what the original order said and how the latest order has shifted?
I do think you are right to put this in context because we're now a year and a half into this second Trump administration, and we've seen signals on AI and in particular AI safety. And I think this is an important new signal. Initially, you had the current administration come in and portray, whether fairly or unfairly, the previous administration that I was part of as too cautious, too focused on AI safety, and with that caution, hampering AI model development by US companies. And in turn, you had the administration emphasizing support to development, fostering of the infrastructure necessary. But this, I think, signals a bit, at least, of a return to that note of caution, not to inhibit development, but to acknowledge that AI presents extraordinary opportunities and some risks. And in particular, I think the recent developments of leading models really built to be excellent at coding, but because they're so excellent at coding, they're also good at identifying coding vulnerabilities, have pushed the needle back in the direction of this EO that we'll talk about, which focuses on how to shore up AI safety a bit.
And when did this come out? And what does it say? What precisely does it say that you can distinguish from the original EO?
So this was issued on June 2, and you're exactly right that there have been reporting on earlier iterations, indeed, what was claimed to be a draft of an earlier version, almost signed by the president, made its way into the press. And we should talk about the main difference between that and the one that was ultimately issued. But I would say what finally was promulgated by the president on June 2 has two main elements. One focused on upgrading cybersecurity with respect to advanced AI, and the second about voluntary disclosure by leading AI companies of what the EO calls covered frontier models before those are released publicly. And I think the thing that's common to these two sections is the piece I mentioned before, the notion that AI, because it's so good at many things, including coding, is also good at discovering vulnerabilities that exist in code. And so the first part focuses on the US government, but also more broadly, cooperation with the private sector to sprint and shore up cybersecurity, essentially before, and this is implicit, bad actors get their hands on the really extraordinary advanced models that thus far have been limited in their release by the companies that have developed them. And then the second piece, and this is the piece that I think got the most scrutiny within the administration before issuance, was creating a multi-layered benchmarking review process led by the national security components of the executive branch to determine which new models qualify as covered frontier models and to work with companies for a period of up to 30 days before those are released to the public to scrutinize what they mean for cybersecurity, for insider risk, for intellectual property, for confidentiality, for the sort of implications of these models in the wild, so to speak.
So I guess this also raises a question because there was an effort to prevent anybody from trying to interfere with the development of AI. I think that was sort of a key feature. And that would have been a situation in which like a state enacted a law that violated the EO in some way or perceived violation of the EO. And I don't hear anything that you're saying that this now takes a position such that that idea that anybody, there were like task force created and so on. What would be a violation of this, or does it just, it's silent on this and we haven't heard anything about it?
I agree. It's almost maybe the right way to think about it is as another narrative thread in the story of AI in this administration. We still have hanging out there, as you rightly indicate, the executive order trying to resist and minimize the impact of state level AI regulation. Now you have at the federal level this push to work even more collaboratively with the private sector on AI safety, especially for cybersecurity. And it's the last piece that I think was, it sounds like from public reporting, the greatest source of debate within the administration, because the notion of even encouraging, urging leading model developers to not release their best new models when ready, but instead take a period of time to bring them to the government, permit the government to scrutinize them, adapt as needed, including perhaps for the government's own cybersecurity. That was, I guess, controversial between some who thought that it was prudent given the cybersecurity implications of these, and others who thought that slowed down that push to develop and release. Ultimately, what it led to was that one notable change I referenced before, in which the earlier purported draft made it in a period of up to 90 days. What eventually was promulgated by the president squeezed that to a period of up to 30 days, presumably the thought being, well, if you're going to slow down what might otherwise be an appetite for private sector release, this slows it down for only a third of the time.
And I guess would the logic of that be that would give somebody time to make representations and things like a quarterly filing, as opposed to it spanning an entire potential quarter or maybe two? It seems odd. And then I wonder how any of these models might be vetted, or what information would then be shared with the administration, and who within the government would receive that information and have the talent and skills to review it for veracity and accuracy. Are those questions answered in the EO, the newest EO?
They're really good and important questions, and they are partially answered, perhaps I'll say. This idea of voluntary engagement by leading U.S. model developers with the government to scrutinize the most serious implications of their models is not new to the CO. It is something that the Biden administration undertook, including through the AI Safety Institute, which was stood up within a component of the Commerce Department. It has continued in somewhat reformulated and renamed fashion under the current administration. That entity got renamed CAISI, the Center for AI Standards and Innovation, I believe. And what this does is it takes that idea and pulls it a bit further. The executive order dictates that this new set of benchmarks for reviewing these frontier models will be classified. And in addition to pointing that out, obviously different pieces of the executive branch can handle classified information. The vibe and the orientation of the CO seems to me to put this work much more in the intelligence community and less perhaps in the Commerce Department. Now, my hope is that the experts of the executive branch across the Commerce Department and the intelligence community and others like the Department of Justice and the Pentagon will be involved in what strikes me as really important collaboration with the private sector. But to the extent one reads between the lines, the idea that these recent models have underscored the risk in a way that pushed this work more into the national security pieces of the executive branch rather than the Commerce Department piece of the executive branch, I think is part of the flavor of this executive.
This is an EO, though. I don't know what obligation the companies would even have to participate in this process. One, because it's not an act of Congress. It's not a law. It's an executive order. And I guess, is this like a lot of executive orders, not exclusive to this administration, that the hope would be that all of these companies would have the desire to do business in the United States, may desire to provide the government with some sort of services and get the benefit of those significant things like DoD contracts and the like. And so they would voluntarily comply, even though somebody's kind of got a boot on their neck saying, comply.
This is critical too, because at least according to media reporting, the debates that led up to the promulgation of this EO were partly about how far to go, including, I guess, some voices seeking mandatory government vetting of models before they're released. Now let's bracket the question of whether there's a legal authority that would justify the executive branch subjecting companies to that, which is very much an open question. But regardless of that, that's not where policy went. This EO does not impose licensing requirements, mandate safety testing, give the government a veto over AI model developers' releases. It does not do that, which means it does do exactly what you said it does, which is encourage them to submit to this process. Now, I think some of them have been already outspoken in their praise for this EO, that they see a role for the private sector and government to collaborate in this space. I also think that whether or not any particular company has enthusiasm for the EO, it's at least worth thinking about where this process goes, because it may begin, indeed it does begin as purely voluntary. Does it find its way into procurement decisions by the executive branch itself for AI models it might use? Does it find its way into regulators' expectations for what reasonable care and safety is when it comes to leading AI models? Does it find its way conceivably into case law around what it means to fulfill one's duty of care if one's a model developer or a model deployer? I'm phrasing all of those with question marks because they really are open questions, but I do think as private sector AI companies think through their participation in this process, they would be wise to think about both what it is for today and for what it might feed into tomorrow and the day after that.
So two questions come to mind, which is, it doesn't sound like there's an enforcement mechanism for non-compliance here. And by a mechanism, I mean a process. So for example, in the context of CFIUS, or the Committee on Foreign Investment in the United States, you don't want a Chinese company or a Chinese entity, especially if it's associated with the state, to acquire something would present a national security concern. And this makes a lot of sense. But what I don't hear is if there's a national security concern here, like you can in CFIUS, you can force a deal to be unwound, or you can block a deal, and there's some sort of a hard stop. And I'm not hearing a hard stop here if something is ascertained about a new model that is significantly concerning and in and of itself would present a national security threat. Is there any of that in there?
There really isn't. If what the government finds in doing this vetting after a company voluntarily submits its new model to it is of extraordinary concern, I think what happens next is a conversation between the government and that company about their plans for release. Conceivably, government could use its own voice to be public and express concern, I suppose. But you are right. This is being done under the auspices of public-private sector collaboration rather than public veto or public threat. Now, I should mention on this piece, one other part of the EO, it is not wholly responsive to this, especially as Justice Department people, you and I, at various times, at least between us, there is a section of the EO that calls on the Attorney General and really the Justice Department to prioritize the enforcement of criminal law when bad actors use AI to break the law. So it cites the Computer Fraud Abuse Act, for example, in which conceivably AI could help one gain unauthorized access of the type that is largely criminalized by statutes like that. And I think having in the same EO a reminder to the public and a directive to the Department of Justice to use that very heavy sanction of when someone's actually misusing, exploiting AI tools to break the law, that should be a priority for the Justice Department. It's just worth it, making sure that's part of our conversation.
One last thought here, Josh, is that in the context of the Office of Foreign Asset Controls, they did previously have a somewhat often used tool, which was blocking pending investigation, where they could sort of block an entity from functioning as a business during a period of time when there was investigation. And there has been a case wherein that blocking pending investigation was sort of unwound in a sense because it was a Fourth Amendment taking of the business entity, which I think was a 501c3. But separately, the issue was that the investigating entity, which I think in that case was the FBI, did not investigate sort of ongoing during the entire blocking period. And so it amounted, because the blocking just went on and on and on, and the investigation didn't appear to be maybe not robust and maybe not even ongoing. And, there were concerns that this amounted to a Fourth Amendment taking. I mean, is there anything in this EO that might anticipate sort of a never-ending negotiation over release of the model because of some perceived flaw?
No, at least not on its face. But you are very right to kind of imagine implementation of this, including at its stickiest rather than at its easiest, right? Its easiest is a model comes in, the government talks with the company about it, they agree how broadly or not broadly it should be released, or on what pacing, or government is given the time to secure cyber defenses it thinks worth securing. And meanwhile, AI model development kind of marches along. But you're imagining conversations that are harder than that, in which after a company submits to this process, the company and the government don't see eye to eye on some element or all the elements of those next steps, the pace, the breadth, the time provided to kind of get ahead of it. And there is not under the CO, and I'm not sure what authority would draw on if they're attempted to be, a sanction, well, thou shalt not if we can't agree on the right pathway here. But I think part of this is to set up that structure and to provide, I would say, an augmentation perhaps of those existing AI Safety Institute turned CAISI processes in which conversations like this have been happening between the private sector and the executive branch, but to augment those, to channel those maybe more in the direction of national security components of the government, and hopefully to find the US government and the US private sector working to ensure that model development continues and that the United States remains at the forefront of it, but also to kind of patch up cyber defenses along the way.
Are there any analog moments in history where an executive that you can think of where an executive order called for this sort of voluntary interaction and it was successful or it was replaced by law at some point and a structure? I know CFIUS was always kind of process was somewhat opaque, right? And I think that was a concern for a lot of attorneys representing corporations or investors. But then a law passed and it was a little bit more clear, what are we looking to constrain against being sold to foreign governments or creating a situation where it would be a national security threat. Can you think of any instance in history where there was this, let's just work together in the private sector and you won't launch your product until we all agree it's okay?
I will come to some decidedly imperfect analogs, but I think I should first acknowledge at the outset, I don't think there is a perfect analog. And the reason I don't think you or I can think of a perfect analog is that the origin of this potentially humanity-changing technology is just different. It's different from the origin of space travel or nuclear power. Things like that began in government and then migrated out. And they migrated out under legal regimes the government set up to determine who should have access to them, with what regulatory oversight, with what classification of certain materials or technologies involved, and so on. And AI came from a different genesis. It came from the US private sector and, to some extent, other parts of the private sector globally, but the leading models have been and thus far remain US origin ones. And so it makes for a different role of government in trying to harness that and facilitate that to some degree, because it is the US private sector and the government wants it to succeed. And I won't say but, and also acknowledge and deal with the national security implications along the way. Now, there probably are some analogs in the world of export control in thinking about what it means for the private sector to have really sophisticated technology and the government to think about where it wants it to go or grant licenses. But this is not that. It is not a regime at all. That's why I say it's a decidedly imperfect comparison. It is not a regime that doles out licenses and says which technologies can or can't go to certain recipients. This is very much a voluntary framework.
Let's see where it goes. I wonder if it'll be followed by additional refining executive orders, some sort of input from Congress, maybe some sort of dialogue between the people developing this, I assume, out of maybe the NSC and the private sector, but also with people who have a high level of understanding of the technology who may or may not be in the private sector. Maybe they are somewhere in the government doing great work. But my guess is we'll be talking again because I see this thing being refined and amended in the near future, probably. And as you said, the pace of technology, it would kind of be crazy right now to set up a regime when it's going as fast as it is. I don't even know how you would do that, how you would secure appropriations. It would be a challenge.
It is moving quickly. And I think the point you emphasize that executive orders and other forms of presidential promulgations are important. We are doing what we should be doing as lawyers to read the text and make sense of it. But implementation matters a whole lot too, and so does resourcing and what funds actually get put towards this, which is partly about which experts get thrown at this problem and actually work on these issues. That matters a whole lot too.
Well, I might have some suggestions where they could find those funds, but I'll keep that to myself right now, Josh. And I will look forward to seeing you next time when this is amended. Thanks.
That sounds great. I look forward to it as well. Thanks so much.
And thank you for listening to NSLT. Be sure to subscribe to NSLT on your podcast app of choice. Please also rate us. Give us a 5-star rating. If you haven't done so yet and you enjoy our nonpartisan content, we welcome you to do that now. Remember, you can like and share this episode with a friend who values civil discussion and facts over clickbait and shouting. And just remember, we're here for you every single week. And we ask you to spend 30 seconds just giving us a little shout out online. So the writer, producer, and host of NSLT is me, Elisa Poteet, always here in my individual capacity, but I'm not alone. Our editor and my co-producer is the lovely Frances Burkham. The tireless and amazing Holly McMahon is a co-producer of this cast as well. Fortunately for me, her workaholic tendencies benefit you, the listener. Our program manager is the amazing and energetic Antasia Hawkins Blakeney, and social media research support comes from Alana Coopersmith. But I would be remiss not to mention that we stand the benefit. Like Kirkland and Ellis, we have the big brains, fortunately, and that is the people on the Standing Committee for Law and National Security who pursue the good and the interest of national security without regard for politics. Thanks so much for listening. We will see you next time.
The views expressed on national security law today have not been approved by the House of Delegates or the Board of Governors of the American Bar Association, and this recording should not be construed as representing ABA policy.